Good morning. You may proceed.
Good morning. May it please the Court, my name is Brett Powell, representing the appellant in this case, Dr. Corliss Rupp. With me is Mick Barnes, who is the trial counsel below, and Dr. Rupp is here as well. This appeal concerns the Board of Medicine.
To reserve any time?
I'm sorry, yes, thank you. I would like to reserve 2 minutes for rebuttal.
Thank you.
This appeal concerns the Board of Medicine's refusal to grant a de novo hearing in Dr. Rupp's case. It is undisputed by the parties and was acknowledged by the Board itself that the hearing was being conducted pursuant to Section 120.57, which mandates that, quote, all proceedings conducted under this subsection shall be de novo. This subsection also requires that the record on review for this de novo hearing includes all pleadings, among other things, all pleadings, motions, proposed findings, and exceptions, and that all of these different documents, including the pleadings and the exceptions, must be considered as part of the review. In this case, pardon me, in this case, Dr. Rupp filed a pleading entitled The Respondent's Objection and Response to Petitioner's Motion for Final Order and Petitioner's Motion to Assess Costs. Obviously, this document is exactly what it says it was. It was Dr. Rupp's response to a motion filed by the department. However, at the hearing, Mr. Telechia, the board counsel, determined that despite the fact that this was clearly a pleading in response to a motion filed by the other party, that this wasn't in fact a responsive pleading. What it was an exception. And because he determined that this was going to be considered an exception, he also determined that the exception then was not timely filed. Because it wasn't timely filed, the board could not consider anything within it, and Dr. Rupp would not have an opportunity to address the board as to anything contained within that supposed exception. From this point forward, this hearing was fatally flawed. The record demonstrates multiple occasions of Mr. Barnes here attempting on behalf of Dr. Rupp to clarify the issues presented to the board, to make arguments as to why a penalty was not appropriate in this case, or to clarify questions asked by the board, only to be on multiple occasions repeatedly shut down by Mr. Telechia and the board chairman, basically told, sit down, you will not be allowed to participate.
You didn't respond within 30 days.
Assuming...
Even though you didn't have notice. I mean, we've got this. I mean, I think it's outrageous. I've never in my life seen findings like this by any organization. I mean, this is not even due process. I don't know what this is. I find it just outrageous that we're even here.
I couldn't agree more, Your Honor, obviously.
I agree. I find that the Florida Department of Health's position and arguments rather disappointing. You know, I won't use as strong as language as Judge Cortines, but I mean, the department is really seeking to discipline a doctor with an unblemished record for 20 years. Who hired Daniel and Yeager to ensure that her medical licenses in Virginia, Georgia, and Florida remained current, and to notify each of the states whenever there was an address change. And these are all undisputed facts. That she was working for a company where she had to move periodically because she provided temporary services. That she moves to Florida and duly notifies Florida of her correct address. She notifies Daniel and Yeager and tells them to notify Virginia of the address change. Daniel and Yeager failed to notify Virginia. Daniel and Yeager closed their Atlanta office without notifying Dr. Rupp. Virginia attempts to contact Dr. Rupp, but is unable to do so because they haven't been notified of the address change by Daniel and Yeager. Virginia finds Dr. Rupp has violated this reporting requirement without her being notified. Dr. Rupp is not aware at all of that proceeding. Florida then initiates an investigation because Dr. Rupp has not notified Florida Virginia's disciplinary action, which she's not even aware of. And even though Florida admits that Dr. Rupp was not even aware that Virginia had taken the disciplinary action against her, and this is how she first learns that this is even happening, that they would take the position that they're taking in this case. I
Did
find
you file for attorney's fees?
Very disappointing.
Under 57105 or other provisions?
We have not filed under 57105, Your Honor. We have not. And
these are real tough questions that you're getting at.
Yeah.
I feel sorry for you.
well, Clearly, the board, the panel here understands our position and sees the inequity here. The only thing I would point out before reserving the rest of my time for rebuttal is we're talking about an address change. This is not patient danger. This is not any issue of malpractice. This is a doctor who moved from Virginia to Florida, advised the company that she contracted with specifically for the purpose of advising Virginia and other states of that change, and due to a mail mix-up, or a mix-up in advising Virginia of a change of address, Dr. Rupp now has 2 blemishes on her record. She's been through, now is the third hearing, and if this court were to remand, it would be a 4th hearing over an address change. Under Section 12068... I just don't think that this is what the Florida Department of Health... Clearly not.
...responsibility should be. To discipline a doctor under these circumstances, I think, is outrageous.
I agree, Your Honor, and clearly under Section 12068, this court has the authority to simply set aside this action. That's what we request this court do. I'll reserve the rest of my time for rebuttal. Thank you.
If it please the court, I'm Phil Monty. I'm representing the Department of Health in this action.
A very difficult position right now.
Well, Your Honor, I would respond by noting that first, it is the board's role to determine how to discipline the licensees under its...
But it's really your position that discipline under all of those circumstances is warranted?
Well, Your Honor...
when she took every step possible to ensure, she hires a company to make sure that this doesn't occur and has the right to rely on the fact that this company is doing that, when she has done absolutely nothing wrong, you think it's appropriate to discipline her?
Your Honor, I'd respond by noting first there were no exceptions filed in this case. And under the case law in Worcester, which I cited in the brief, that effectively cuts off any right to appeal issues of law or fact contained in the ALJ's recommended order.
So you're going to stand here and try to argue technicalities and to try to
Well, no, Your
convince
Honor,
us that the position you've taken in this case is appropriate?
Well, let me respond, please. With regard to the requirement that she update her license information with the state of Florida, including any discipline from other states, I'd like to first note that she is not appealing the conviction on subsection B of 458.331, subsection 1. And in fact, she apparently accepts the fact that she is to be disciplined under Florida law for the conviction under Virginia law. And so there doesn't seem to be any dispute regarding that. Now, with regard to the requirement that she report to Florida discipline in other states, well, in her particular situation, perhaps it's not, it doesn't appear to be so serious, because I will concede it's a relatively minor discipline that occurred in Virginia. However, assume that she was, in fact, accused of sexual misconduct with a patient.
That's not the assumption. This is my problem. How could any legal body at all, with any semblance of legal authority and logic and rule of law, make these 2 statements? She could not have notified the department within 30 days of the date the order was entered. That's what the ALJ found. She could not have done so.
Yes, sir.
And then goes on to say, by clear and convincing evidence, we find the violation that she didn't notify the department within 30 days. Those 2 just don't mesh.
Your Honor, on the face of it, the statute in question is quite clear that it's not to be reported from the date of knowledge of the discipline, but when the discipline occurred.
But when the ALJ said she could not have done so.
But, Your Honor, that's because she did not receive that notice within the time to respond to Florida. However, had she kept up her Virginia information, had she had her address information on file with Virginia.
Let's talk about laws that require people to show up for jury duty.
Pardon, sir?
Let's say there's laws that require you to show up for jury duty.
Well, there are laws that require...
The state says, we didn't send you a notice, but you're on the list.
Your Honor,
You think that we can say you didn't have notice, but it says you've got to be here.
Your Honor, I believe the more appropriate analogy would be the requirement that I be responsible for keeping proper and current information with the bodies with whom I'm dealing as a licensee of the bar, for instance.
But it was undisputed that she attempted to do that she hired a company to do that.
But, Your Honor, negligence won't excuse me, for instance, if I file a brief late in this court because I say I gave it to a company to file it for me, or I gave it to my assistant to file it for me. This is one isolated instance, but the rule of law is at issue insofar as we have hundreds of licensees to deal with. It is absolutely essential that they notify us of the current state of their license, including whether or not it's in good standing in other areas.
What is the purpose? I mean, I think you're not focusing on what's the purpose of the notice. The purpose of the notice is so that you can make sure that they don't have some other bad history somewhere else that you don't know about. You're trying to protect the patients and the state. But the fact that Virginia did not get her license, her address changed to Florida, and Florida has, her new address, but the fact that they didn't get it in a timely fashion because the company she hired to do that didn't do it.
Your Honor, but she stated, if you look at the record,
protects the patients?
Page 230 of the record, Your Honor, she admits in a letter to the State Board of Virginia that as long ago as 2002, she had suspicions about the competency of Daniel and Yeager. I just don't believe, for instance, the Florida Bar would accept.
I read about all these doctors that commit malpractice in other states and come down here to Florida, and you guys do nothing about it, and yet for an address change, you're even bothering to prosecute. Why aren't you going after all those bad doctors that are out there killing people? I mean, this is outrageous, and the fact that you get up here and you argue this, I mean, I wish you had run into Judge Schwartz 10 years ago. You wouldn't be standing anymore.
Are there any other questions
No,
of the court?
thank you.
Thank you.
And I do suggest you file a motion for attorney's fees under 57-105 because this is as frivolous a case as I have seen in a long time.
Thank you, Your Honor. Very briefly on rebuttal, the one point that I would like to address. When the department says that we take no exception to the other issue here, in fact, we did. In an attempt to discuss that before the panel, before the board, those arguments were raised as to whether it would be appropriate under the facts of this case to impose a penalty here. The board may well have agreed with Dr. Rupp that this panel apparently, that this is not the kind of case that requires an imposition of penalties. But Dr. Rupp was deprived of the opportunity to do that because of the undisputed failure of the board to follow statutory procedure. There are two undisputed facts in this case. One is that Dr. Rupp did not get a de novo review and that the documents filed on her behalf were not considered. And two indisputable facts, that she had a right to a de novo review and she had a right to have those documents considered. The board's failure to do that, in my opinion, and I urge this court, justifies setting aside the action taken against Dr. Rupp instead of remanding this for a fourth hearing over an address change.
Thank you.
Thank you very much.